Good afternoon, everyone. Welcome to our seminar series for caregivers and family members. And today we will be speaking on the estate planning and understanding all of the basics. Our guest speaker today is Attorney Ayana Johnson. And Attorney Johnson and I are in the Prince George's Senior Provider Network. And so you are in for a great presentation on estate planning today. You can move forward. All righty. So most of you know me from previous presentations. I'm Jennifer Tillman. I'm a real estate agent with Keller Williams Preferred Properties for over 17 years. And I'm also a member of Prince George's Senior Provider Network. In my real estate work, I serve caregivers, seniors, baby boomers, first-time home buyers, all of the people that are in various transitions. It could be a first home, so you're transitioning from renting. It could be that your family's growing, you're moving up, you're moving down because your kids are out to school. And then it could be that you're moving into an active community. All of these are transitions. And so I work in that real estate field as a transition specialist. Through my time in real estate, it's like ministry work for me because my clients invite me into their families, into their homes, and to their lives to help them through this transition. And so I decided to begin coaching. And so I have a coaching business as well. And one of the latest tools or things that I've added to my life coaching is grief coaching. So later this year, you hear a presentation on journeying through grief. And I look forward to inviting you to that as well. You can move forward. So what I've also created is a Caring for the Caregivers Facebook page. And on this page, we share lots of information that's going on in the county. We really need to step it up a little bit and make sure that we are adding lots of information there. But this is where you would also get information on what's coming up in the seminar series. So you can either click on the link there, scan the QR code, or you can just go to Facebook and look for Caring for the Caregivers in Prince George's County, where you can mastermind, it's other people that are caring for their loved ones as well. So that's a great page for you to get resources as well. And then the very next slide just has my information as to how to reach me. Again, Jennifer Tillman with Keller Williams, and also in my coaching business, Be Inspired by Coach Jen. All right, so now I'm going to turn it over to our main speaker for today. I'm happy that you guys are with us. We're going to have question and answer at the end. You can put your questions also in the chat, and we'll go back and review some of those. And I look forward to hearing this presentation. Sit tight and enjoy. Thank you, Attorney Johnson, and you can take it over now.
Thank you so much, Jen, and thank you everybody for being here. I really appreciate it. And I am excited to present to you pretty much a basic kind of background and framework for doing estate planning. I would say the biggest things about estate planning are that a lot of folks want to make sure that they're protecting their family, that they're making sure that the wealth that they have worked so hard to accumulate and build during their lives is actually protected and passes on while minimizing taxes, minimizing random strangers or third parties from getting a hold onto it. So I'm really excited to be here and to tell you all about this magical world of estate planning. Before I get started, I do want to share a little bit about myself. So I am an attorney. I do estate planning work. This is what I do. I will not help you with, a contract dispute or things like that. I am just an estate planner. And that gives me the freedom to really hone and perfect that craft. So I am an attorney, as I said. I practice in DC, in Maryland, and in New York. I have a background, of course, in estate planning, but also in family law and criminal law. Although now I am a boutique law firm, as I said, that just does estate planning. And the values of my law firm are really quite simple. My goal is to help families plan and to make sure that they're actually preserving their wealth, building generational wealth, and creating a positive future for their loved ones where we're minimizing fighting, minimizing taxes, minimizing all the things that nobody really wants to see happen once they're gone. So a little bit of an agenda here today. We are going to talk about, of course, the foundation of estate planning. And I'm going to start that off by sharing terms that I think are really important to know. We're going to move into what really important estate planning tools are once we have the terms down pat. And then we are going to move into the importance of actually planning ahead. We're going to move into individualized goals, which will also be a bit of a theme throughout our session today. And then, of course, at the end, there's going to be a little bit of time for some Q&As. As Jennifer mentioned, feel free to utilize the chat feature, and we'll get to those questions at the end. So as I said, I think it's important to start off any presentation with building kind of this groundwork. And I think that the groundwork is really the terms, knowing the terms that actually define the things that we'll be talking about. So I like to start with this idea of trust, because trusts are one of the things that I most often get questions about. And there are a lot of sources of information about trust, some of which are good and some of which maybe are a little confusing. So just starting with the basics as to what a trust actually is. So a trust is a legal entity. It can hold assets, and any of those assets that are within the trust will be controlled by the instructions that are left behind in the trust. So it's a legal entity. It will hold your assets for you, and it will have instructions included on how the assets will be managed and ultimately distributed. The trustor, aka grantor, is the person that actually creates a trust. So the person that sits down with an attorney, creates a trust, and puts their assets into that trust is considered to be a trustor. And then we also have a trustee. So these are the two big players with the trust. We have the creator and we have the manager. The trustee is the manager of the trust. They are the person that makes sure that the instructions are actually being followed. Oftentimes, the person who creates the trust is often also the trustee while they're alive and well. But then it's important that we have named successor trustees. The successors are the people who will step in when that first trustee can no longer act. Maybe that first trustee has passed away, maybe they're just slowing down, and you have these successors or backup people or entities that will actually step in and do the job. And then, of course, we have beneficiaries. We know beneficiaries. They are present on our life insurance policies from work, on our 401ks. Beneficiaries are the people who will actually receive an inheritance from the trust itself. I want to move into the world of wills, which is a little bit different. So last will and testament, I'm sure we've all seen on TV or in movies, but that's a document that says when I'm gone, this is where I want my things to go. And a testator is actually the person that sits down and creates a last will and testament. If you are a woman, you're the testatrix, kind of the gender identifying version of the word, but it is the person who actually sits down and writes a last will and testament. Now, a personal representative, also known as an executor, is the manager. So that's the person who will actually make sure that the testator's wishes are seen through and honored. And of course, just like a trust, we want to have successors. So if our plan A doesn't actually come to fruition, we always want to make sure we have a backup individual or a backup entity who can step in and make sure that our wishes are honored. And then, of course, again, we have beneficiaries. And here are a couple other kind of terms that don't necessarily fit into the umbrella of a trust or a will, but they're still incredibly important to know and understand because these different things also play a part in an estate plan overall. So of course we have a power of attorney document. I'm sure many of you have heard of a power of attorney before. The power of attorney is a document that actually grants legal authority to someone known as an agent. And that agent can actually make decisions on behalf of the principal. So there are two types of power of attorney, which you'll notice the last part of the slide. There's a financial power of attorney and a medical power of attorney. Your financial power of attorney is going to be making any financial decisions on your behalf. And your medical power of attorney is going to be making all of your healthcare decisions on your behalf. The principal is the person who actually sits down and creates a power of attorney. They name who their agents will be, and they grant certain powers to their agent, which can be limited or can be unlimited. Then we have the agent, of course. That's the person who actually acts on the behalf of the principal. And like the trust and like the wills, we want to have successor agents. We want to have backup individuals just in case our number one choice of a person is not available. And I do always mention to people that this agent is not just someone who's just doing you a favor. This agent actually is going to be taking on the role of fiduciary. And when you have a fiduciary, it's important to know your fiduciary has duties. So they don't just have to do you this favor or do it if they feel like it. They actually have legally binding duties. And the biggest duty of those is to act in the best interest of the principal. So that means even if they have to take an action that wouldn't be in their own best interest, as long as it's in the best interest of the person who they're serving for, they have to take that, make that decision. So this is kind of laying the framework for the other pieces of what we'll talk about, which is really the tools. So we've talked about all the tools and knowing the terms. What is actually the purpose of the documents? What are the big documents that tend to make up an estate plan for folks? So first and foremost, we have a revocable trust. This is an incredibly common estate planning tool. And again, it's that entity that you can create, which is going to manage all of the assets that are actually in the trust. While the trustor is alive, the trust is going to be used to support the trustor. So let's say, for example, you move a bank account into the trust. That money in that bank account can be used for the benefit of the trustor. A revocable trust is special in that it can be amended, it can be changed. And so long as you create your revocable trust properly and you fund it properly, you will be able to avoid the probate process, which we'll talk a little bit more about in just a moment here. Now, I also want to talk about a last will and testament again, which we've already discussed, but just as a reminder, it's that document that's going to say, when I'm gone, this is what should happen with my assets. It's important to keep in mind that having a last will and testament will not allow you to avoid the probate process. In fact, the last will and testament is filed with the courts to direct how the probate process should go. A power of attorney, of course, is a document that you are going to create to provide another person the power to step into your shoes. They can act on your behalf either in the world of finance or in the world of medicine. You can have the same person in those power of attorneys, or you can have different folks. Sometimes people have a sister who's a nurse, so they'll name them as the medical power of attorney, but their son is a financial advisor, so the son will be the financial power of attorney. Those two different documents work together, kind of serve different roles. We also have medical directives, which are incredibly common estate planning tools. These medical directives allow you to make your end-of-life choices well ahead of time by actually writing down what you want if you're ever in an end-of-life situation. In my opinion, this is one of the most important estate planning documents because this is the type of document that without this document, you may be setting up your loved ones to start bickering about what should happen to you if you're ever in an end-stage condition. If you ever came to be in a vegetative state, would you want to stick around? Would you want to be kept alive? Or would you want to be allowed to just pass naturally? Everyone has their own quite strong opinions about this. So it's not something you kind of just want to leave up to interpretation. You should just let your loved ones know what you would want if you're ever in that situation. Now, of course, I want to mention that there are other types of trusts. Today, we're really going to focus on the revocable trust, but there are other types of trusts. So depending on what you actually want to do, what you want to achieve in an estate plan, you may need a different type of trust. You may want an irrevocable trust or a charitable trust or even a special needs trust. There are many different types, some of which are revocable, some of which are not. So it's important to keep in mind that although a revocable living trust or a revocable trust is the most common type of trust, you may want something a little different depending on your goals. So I want to talk a little bit about the difference between a trust-based plan and between a will-based plan, because these two documents, one of these two are going to be the heart of your estate plan. So if you have a trust, the trust is going to be the heart of your estate plan, but it should still have some supporting documents. If you're going to have a will-based plan, the will be the base. It'll be the heart of your estate plan. So when you have a revocable trust, things are going to work a little differently. If you set up a revocable trust, you will actually take the time to retitle your property into the name of your trust, or potentially, depending on the type of asset, you might name your trust as the beneficiary on an account or on that asset. The important thing here is that you are making sure that your assets are either in your trust while you're alive or upon your passing will move into your trust. When I say retitling property, I quite literally mean you will be taking your direct name off of your property and moving it into the name of this trust. And the trust assets will be ruled by whatever terms you decide to lay out in your trust. So like I said, a lot of people end up being the trustor and the trustee initially, meaning, for example, you move the deed to your home out of your name and into your trust name. If you are both the trustor and the trustee, you can choose to sell your home, refinance your home, really do anything that you'd like with your home. Because it's in the name of your revocable trust and you're both the trustor and the trustee, you can do anything you want with it. But you have put terms into that trust that say, when I no longer am the one managing this trust, or maybe when I'm no longer here to use the assets for myself, this is what should happen with those assets. Now, on the flip side, a last will and testament is really only working on the back end. It's not going to be working while you're alive to do anything. It's going to kick into effect once you're no longer with us. So when you have a last will and testament, probate will be opened. The last will and testament will be filed. Your personal representative or an interested party will file your will with the court, and the assets that have any beneficiaries or POD or TOD listed will go to those people, and everything else will be ruled by the terms of your will. So if your will says split everything equally between my two children, that's what will happen. It will happen through the probate process. So the court will be overseeing that entire process and making sure that everything goes according to basically the framework that the courts and the state of Maryland have set up. So I want to talk a little bit more about a trust, just because I find that wills are pretty straightforward, right? I write down what happens when I die, and that's what happens. But when you have a trust, things work a little bit more, I don't want to say necessarily in a more sophisticated way, but things are slightly more complicated because you're creating this entity, and this entity will be functioning not only while you're alive, but also once you pass away. So I like to look at the way that a trust functions in phases. So generally speaking, you can consider 3 phases of a revocable trust. The first phase would be while the trustor or the creator of the trust is alive and acting as the trustee or manager. During that time, the trustor can use the assets in that trust however they want. Like I said, if you moved your house into your trust and you were both the trustor and the trustee in phase 1, you can transfer your house to your trust. You can sell your house and buy a new home in the name of your trust. You can refinance, you can do really anything you'd like with that home. But during phase 2, we have a situation where the trustor or the creator of the trust is alive, but they are not acting as the trustee. Instead, we have one of the successor trustees acting in that role. So that means the person who created the trust is alive, but they are not acting as the manager. In that case, the person who's managing the trust, the successor trustee, still has to use all of the assets in the trust for the trustor's benefit. So in that situation, if you have your home in your trust, titled in the name of your trust, you can still live there, but your trustee will be making sure that the mortgage is paid, will be making sure that the bills are paid, all of that good stuff. So the trustee is still going to be managing the trust, but they have to spend the money on the trustor while they're alive. Until we get to phase 3, in which case the trustor has passed away. In that case, the successor trustee, who is basically being the manager of the trust, is going to take stock of all the things that are still in the trust, and they are going to distribute those things to the beneficiaries that the trustor put in the trust while they were alive. So they are basically going to make sure that everything that's in the trust, once you're gone, actually goes to the people who you want it to go to. So I'm an incredibly visual person, so I like to look at things as a graph or as kind of a diagram. So I find that this may help for anyone else who's visual who might be tuned in today. We're actually talking about how a trust works. I want you to consider this kind of wine-colored box on the screen to be the revocable trust. Think of the trust itself as a box. And when you create this trust, you will move, for example, your home. I know I'm an excellent artist. Your home that's drawn there within the box, you would transfer that to the trust, and then it would be considered in the box. That dollar sign I want you to consider as a bank account. You would retitle your bank account into the name of your revocable trust. So some things will be sitting in that box. Other things, however, may be sitting outside of the box, but the plan is that they will move into the box once the trustor passes away. So for example, a checking account. You would name your trust as a beneficiary. So although it's kind of hanging outside of the box now, eventually it will move into the box when that person passes away. Life insurance can work similarly in that you keep it in your name while you're alive, but you name your trust as a beneficiary so that upon your passing, that money will funnel into the trust. Now you'll notice there are a couple of green assets here on the side of the screen. We have a vehicle and an IRA. So these are 2 examples of an asset, or assets I should say, that will not necessarily go into your trust. So your vehicle, let's say for the purpose of this example, you just name your son. Straight up, my son will be the beneficiary. You can do that on the title through the MBA. You can do that on the title of the vehicle and name your son as the beneficiary. And for the IRA, let's say you put your spouse as the beneficiary. Let's talk about how this will actually work once the trustor passes away. So you can see those things that were supposed to funnel into the trust are now into the trust. We still have the house in the trust. We still have the 1 bank account in the trust, but now we see the checking account is in the trust as well as the life insurance policy. And you will now see an arrow going below because the trustor in our example has named their grandchild as the beneficiary. So everything will be moved into the trust, and the grandchild will ultimately receive the assets that are in the trust. On the flip side, oh, I'm not sure why this graphic has messed up like that, but on the flip side, we see that the vehicle and the IRA are going to pass to the son and the spouse. That will never interact with the trust. It'll go directly to the son and directly to the spouse. It will not interact with the revocable trust, and it will not have to go through probate because we've named beneficiaries on the assets directly. So we have effectively avoided probate. Although different assets are treated differently, we still have the end result, which is avoiding probate and making sure that the people who we wanted to inherit certain things are ultimately getting those things. So let's talk about the importance of doing all this, right? Like, we're talking about all of these different legal documents, all of these different kind of situations in which we will treat certain assets certain ways or make sure that certain people get things, but why do we even care? Why is it even important? Well, I will say one of the number one things that folks come to me hoping to do is hoping to avoid probate. And I've used this term probate without fully explaining what it is, so I want to talk about it just briefly here. Probate is essentially a court process, and it's a process in which when a person passes away, we cannot have assets stay in the name of the person who is dead. So we need the court to oversee a process in which we're taking assets out of the name of someone who has passed away and moving those assets into the name of someone who's alive. So the court process known as probate oversees that process. A last will and testament will guide the probate process. So if there is a will, that will be guiding the probate process. If there is not a will, the state in which that person lived has a plan for where those assets will go. So for some people, they're okay with just not putting anything together and kind of letting the courts decide, letting the government decide. Most people don't like that, but some people don't really mind it. It is important to keep in mind, though, that probate is public. So anybody who would want to know what you left behind or who you left it to, they can show up in court. In fact, I often show up to court and listen to many probates before my court case gets called. I oftentimes will log in just to listen, just to hear what's going on in the probate court. So a lot of courts are still virtual, some are in person, but anybody can go. Nosy people can come. People who may want to challenge your will can come to the courtroom and hear what the will says and what you've left behind. So a lot of people are bothered by that piece. Sometimes people will tell me that they got a phone call from a random number about trying to get a house sold to them. They don't even know how these people got their information, their phone number. It was oftentimes through the probate process because all of that is public record. So I want to take a moment just quickly to talk about the pros and cons. I'm sure you can tell what the cons really are by how I've already talked about it, but the big cons that really exist with the probate process are time. It is a time-consuming process. It's public, so anyone can know what's going on in the probate process. The cost that's associated, whenever you go to a court, know that you're going to be paying some level of fees. There are filing fees, court fees, there can be attorney's fees. If people start to argue, which oftentimes happens when it's a public process because people show up, they want this, they want that. If you start to argue and litigation ensues, that's even more of a cost. And then I have the court overseeing the process as half con, half pro. So depending on what your situation is, some people like the idea of probate. Some people don't have anyone in their life that they really trust to do this work, to make sure that their wishes are honored. So they would actually prefer to just have the court oversee the whole thing. For other people, they don't like the idea of the bureaucracy that comes with the court process, the public nature, the cost. They want it all handled privately. So they do not like the idea of probate at all. So it's a half pro, half con, kind of depending on what your situation and what your desires are. But another reason why estate planning is important is because of something known as an estate tax. So really there are two death taxes that you should keep in mind. The first of which is an estate tax. An estate tax is based on the overall value of a person's estate when they pass away. Think your home, life insurance, retirement, any asset that makes up your estate, the estate tax will be essentially calculated based on that. Only if you're above a certain amount of money. So if you were to pass away and your estate is under $5 million, you do not need to worry about the estate tax. Federally right now, it is $13.6 million. However, if Congress does not act to bump that number up, it will bump back down to $5 million. So if you do have over $5 million and you passed away in the next few years, you may get hit both by the state and by the federal government. It is a graduated tax, so you will see there's kind of varying tax rates depending on how much money you have over that threshold amount, but that's a state tax. For a lot of folks, there is planning in place where you can avoid or minimize estate tax. That's where we kind of throw it back to those other types of trust, the non-revocable trust or the specialty types of trust. So again, and I can't really say this enough in this presentation, a lot of this is going to depend on what your situation is and what your desires are. So if you have a taxable estate and you want to make sure that you're minimizing taxes, we're going to take different steps than someone who doesn't have to worry about the estate tax or doesn't care about the estate tax. Now, I mentioned that there are two death taxes. So we have the estate tax, but we also have something known as inheritance tax. Inheritance tax is totally separate. It's based on the relationship between the person who is deceased and the person that they've left money to. So some people are exempt from the inheritance tax. Think kind of the nuclear family, your siblings, your parents, grandparents, children, grandchildren. Those are all the folks that are exempt from inheritance tax. But pretty much everyone else has to pay inheritance tax. So if you leave money to a nephew, if you leave money to a friend, a cousin, they will all have to pay inheritance tax. That is a 10% tax rate in the state of Maryland. So I also want to talk about the importance of estate planning when it comes to different types of beneficiaries. So some people, of course, have two grown adult children. They trust them with an inheritance and they just want to give it to them outright. That can absolutely be done in an estate plan. But some folks have different types of beneficiaries, and it's important to keep them in mind when you do your estate plan. So you'll see here across the screen, there are multiple different types of beneficiaries. Of course, minor children. So minor children, if you wanted to leave any money to someone under 18, they cannot inherit that money directly. So those individuals would have to essentially have that money managed by someone else. If you name that person, great, you can have the control over that. If you don't, most often it's going to be their guardian or their parent that's managing the money for them. You may be comfortable with that. You may not be comfortable with that. Again, everyone has a different situation. We also want to make sure we're keeping in mind special needs beneficiaries. And when I say special needs beneficiaries, I don't just mean folks who are differently able. I mean people who are dependent on any type of government benefit. So if you're dependent on a government benefit, and receiving a large inheritance would essentially disqualify you from that benefit, it's really important that we're planning especially for those people. So we want to make sure that we're planning in a way that's not going to leave them worse off than if they never received anything from you. Of course, we have our folks who are unable to manage money. We want to plan a little differently for those beneficiaries. So for some people, that means that we are giving a little bit of money over a long period of time to that beneficiary so that they don't just blow it at them all in one afternoon. And then finally, I want to talk about the types of beneficiaries who are in conflict. So if you have beneficiaries who do not get along, do not like each other, who are very likely to start arguing, it may be important to make sure that we're including certain types of clauses or limitations to how they get the money, the way in which they are able to inherit the money. We want to make sure that we're planning for that. So we do have different types of beneficiaries who may cause our plan to be molded slightly differently. And it's important that you keep that in mind when you're thinking about, is it important that I even put together a plan? Now, one thing I always like to impress upon people is if there came a time where you were alive, but you could not handle your affairs, what happens then? A lot of folks like to think, well, I can just access my parents' bank account, or it's my spouse, I can access their bank account. The answer to that is no. If you are not on the person's bank account as an authorized user, as an owner, you're not able to access their bank accounts. So if they start to forget to pay their mortgage, their gas bill, their light bill, if random transactions start happening from another country, from overseas, where there are these constant withdrawals of money, it's really important to be able to catch those things, to be able to make sure that you are able to help them. And you are able to do that with the power of attorney quite easily. But if you do not plan ahead and you do not put a power of attorney in place, the only option is something known as guardianship. And again, that causes us to go back to the courthouse. And in a guardianship proceeding, you essentially have to tell the court, here are all the ways this person cannot care for themselves, and here are all the reasons I should be appointed to care for them. Now, I'm sure this goes without saying, it's incredibly embarrassing. It can be quite a bit dehumanizing for someone to go into a courthouse and talk about all the ways you're not able to care for yourself. There's not really a reason to go down that route. The time consumption, the cost of actually going to court again, when you can just avoid all of that with the power of attorney, seems pretty straightforward, but it's one of those things people don't really think about. Even in the world of estate planning, oftentimes people are focused on, well, what happens when I'm dead? But there is so much more to it than just if you were to pass away. If you needed help when you were still alive, arguably that's more important than what happens when you're not with us anymore, because that will still affect you. Another important thing about guardianship is you have people who are petitioning the court. The court doesn't know anything about your family. They don't know about how this person feels about you, how they get along with other people, how they tend to manage or make medical decisions for you. They don't know. They only know what that person presents to them. They have no way of knowing really the nitty-gritty of things. So you can have a guardianship in which you don't have any power over who gets the power over you, or you can just put together a power of attorney, which is incredibly straightforward, and you get to make sure that your wishes are honored. So you get to choose your decision maker. You don't have to go to court and either fight to prove that you don't need this help or have other people fight to prove that they are the good person to give you help. You can totally avoid guardianship. I do not recommend going through it if you don't have to. So moving on to one of the other really important parts of putting together an estate plan, which is your end of life wishes and your care instructions. On this same note of it's not just about when you're gone, but it's also about when you're here, we have to talk about end of life wishes. So one of the biggest things, and I believe I mentioned this in the beginning of the presentation, but one of the biggest things that I see people starting to argue about, starting to see relationships break down, is when their loved one gets sick and they and another family member do not agree about the care that that person should receive. So if you were in an end of life situation, what would you actually want? Would you trust your son or daughter to make decisions about the care that you should get? Would you want to leave a really, really hard decision like pulling the plug on you in another person's hands? Also keep in mind that there is often a level of second guessing when it comes to that. I don't think it's ever incredibly clear what you should do when a loved one is in that situation where you have to decide, do I keep them on life support or do I let them go? Incredibly, incredibly hard decision to make on your own. And it is possible to plan ahead of time, put your wishes down, and kind of alleviate the guilt that comes with leaving that decision into another person's hands. So you can make sure that your wishes are going to be known, and you can make sure that they're going to be honored just by planning ahead and making sure that those wishes that you have are actually memorialized. Now, I also want to talk about the last really important thing as far as estate planning goes when it comes to why is this actually important. A lot of people have special wishes. A lot of people just generally want to make sure people don't fight. Some people have more specific special wishes though. Some people have a pet that they really care about that they want to go to a certain place. I actually just recently learned how long pet birds live. I didn't realize how long they live. I think at the end of the day, a lot of people don't think about the fact that if you were to pass away and there's no family member or friend who wants more pet, a lot of times they end up at kill shelters. So a lot of people want to make sure that they're planning for their furry friends, especially here in 2024. A lot of people have family heirlooms like their mother's engagement ring or other kind of things that have a lot of sentimental value that they want to make sure get passed down to their daughter or their son or whoever that person may be. So when you have those special wishes, they will not be honored unless they're written down because people just don't know. They don't know, and then sometimes they don't have the legal authority to actually see those wishes through on your behalf. So all of these are incredibly important reasons to actually put together an estate plan. And of course, we have to talk about the fact that almost everything that we've talked about today has to do with your individualized goals. There is not a cookie cutter, one size fits all estate plan that will make everybody happy or that will serve everyone's goals. Everyone has different family situations. Everyone has different assets. Everyone has different goals. You have to be able to think about the things that you really want to be included in your estate plan and communicate that with someone who can help you actually put an estate plan together. And I have to share one of my favorite quotes here. This is, the way to get started is to quit talking and begin doing. Estate planning is one of the #1 things that is always on the to-do list, but it's never at the top of the to-do list. It's always somewhere in the middle or towards the bottom. Oftentimes it's something that only becomes pressing and only becomes a priority once a loved one passes away and that person's going through the probate process or going through a guardianship process while the person's still alive. Once they see how much of a headache it actually is to do it for someone else, they want to make sure they don't put their other loved ones in that situation for them. So I just include this quote to let you know, planning ahead, knocking it off the to-do list is just the best way to do it. So looking forward as to what actual next steps are. If you have listened to this presentation and you think, I should get that will from 1999 out and see what it says, or you're thinking, I need to put something together in the first place, what does it actually look like to put together an estate plan? So of course, #1, you want to make sure that you're choosing an estate planning attorney you feel comfortable with. If you sit down in an office with someone and you think, I shouldn't tell them that I have a child that I don't speak to. I shouldn't tell them that I want to disinherit someone. I shouldn't tell them this or that because they'll judge me. that's a no-go. You have to be honest with your estate planning attorney about what you want to see happen, or else they can't make it happen for you. So you want to pick someone who you feel is a good fit for you. You should make sure that you feel understood. And you should also make sure that you understand what they're putting in place for you, because these are legally binding documents. So you want to make sure that you feel comfortable asking questions about what you're getting put together and what it actually means. So when you are considering an estate planning attorney to hire, of course, I'm excellent at doing this, but if you do choose to look around and see an estate planning attorney maybe in Virginia or somewhere else where I'm not licensed, or you're just trying to compare, there are some things that you should consider. They're all here on the screen, but I'll touch on all of them kind of briefly here, just in the interest of time. So some of the considerations you should think about are the process. How long is it going to take me to actually put these documents together from the time I sit across the table with this attorney to the time where I'm signing everything and it's actually in effect? Is the process going to involve multiple different people, like 5 different paralegals, 3 different attorneys? Are you going to work with the same people, different people? What does it look like? You also want to see whether or not there are document packages available. In the world of estate planning, a lot of estate planning attorneys will recommend that you do multiple things at once, just to make sure that everything is airtight. So you want to make sure that if you would like to do your power of attorney and your will and your trust at once, that attorney can take all of that on at once. You also want to see on the flip side if they only do a la carte work. So if you wanted just a power of attorney, or if you wanted just to do an advance directive, or also known as a living will, can you do that? A really important thing is whether or not your attorney will work on an hourly rate or a flat fee. I find this to be important because estate planning is a pretty complex area of law. I know I've broken it down kind of into digestible pieces today, but if you are going to want to be able to call your attorney and ask them a question and make sure you're not racking up the bill, you may want to go with someone who works on a flat fee basis. Or if you want to work with someone, get it knocked out, you don't have any questions, you know exactly what you want, maybe an hourly attorney would be better. So think about, again, it's not cookie cutter, it's not one size fits all, but think about some of these different things when you're picking an estate planning attorney. Now, of course, you see price there. I don't really have to say that. You want to potentially be comparing prices. I will tell you, when it comes to the world of estate planning, oftentimes you do get what you pay for. So if things are seeming suspiciously cheap, there might be a reason for that. Estate planning is one of those things that a lot of people will dabble in, but if you really want your estate plan done right, you want to make sure you're going to an estate planning attorney who generally doesn't practice this, but that specifically practices this area of law. And finally, when you're looking for an estate planning professional, you want to look at what the ongoing support looks like. Are you going to be able to call them in 10 years and review the estate plan? Is it going to cost you an arm and a leg to do so? Kind of how all these different law firms are set up between the process, the offerings, the price. These are the things that you want to be considering when you're picking an estate planning professional to put together your plan for you. You also want to make sure that when you do find someone, that you are going to get the most out of your consultation. So the scheduling is up to you. Do not schedule an appointment when you're on the way home from work or when you know you're going to be stressed with different things. You want to make sure that you're scheduling at a time you're not going to feel rushed or distracted. If you would like, many estate planning attorneys like if you can gather your asset information ahead of time. So things like your bank statements, your quarterly statements, different things like that, if you want to gather it ahead of time so you have a better idea of whether or not you need to worry about the estate tax. And then finally, you want to make sure that you're thinking ahead of time about who you would actually trust in these important situations. We've talked about potentially having a power of attorney, having someone who has power over all of your medical decisions or over all of your finances, or who you would trust to be the trustee of your trust or the personal representative under your will. All of those things are incredibly important. And who do you actually trust to do that? And also, who would you like to inherit money from? Do you have a charity in mind? Do you want to make sure you're giving to your alma mater? These are all things to consider ahead of time to make sure you're getting the most out of the consultation that you set. So in summary, I hope you have learned at least something today about estate planning. If you would like, go ahead and check out my website. On the screen is a typo. It is just johnson-legal.co. You don't have to type in the www. But I do have further resources there. Again, I hope you've learned at least something about estate planning. Maybe you have become inspired to review your estate plan if you have an old one in place, or maybe you're ready to get started on putting your estate plan together. So I want to thank you all again. I did save a few minutes here for questions. So if you have any questions, please go ahead and throw those in the chat.
Yes, thank you so much, Attorney Johnson. So we do have one question right now in the chat. And it is there a way to avoid the probate process even with having a trust?
Yes. So you can avoid the probate process with a trust.
Okay, so having the trust will avoid the probate process. And I guess having the trust, if you don't, if you put the things in the trust, because of course, if you have a trust and you only have the home in the trust, and then you have maybe bank accounts or something else that you never put in the trust, then those things that are out there maybe didn't have beneficiaries or whatever. I guess that's the part that would go to probate. Is that correct?
You are absolutely right, Jennifer. Yep.
Okay, so the idea is to make sure that all of the assets go into the trust either initially or upon death. Can you, Ayana, I know everybody might not be familiar with TOD and POD.
Yes. So TOD is transfer on death. You can have POD, payable on death. It's essentially the same idea as a beneficiary being listed on an account.
Okay. All right.
And
And
I did get a couple of direct messages as well,
okay.
Jennifer.
Okay.
I got one question about a caregiver. So as a caregiver of your spouse, what options, if any, do you have to specify who cares for them if you pass before them? So I really do want to address this question because it's a really good question. Having documents set up ahead of time is important because if you do not have the legal capacity to set up these documents, an attorney cannot set them up for you. Sometimes I have caregivers coming to me attempting to get documents set up for people. Sometimes I have children coming to me with their parents who are in late stages of Alzheimer's. I cannot prepare legal documents for someone who doesn't understand what the documents are. So that being said, just because you have a diagnosis of dementia or Alzheimer's, that doesn't mean that you necessarily lack capacity. If you're far on in that process, you do definitely lack capacity. But essentially, if somebody could sit down across from me and say, I want to avoid probate, this is who I want to be in charge of me, this is who I want to inherit from me, that's capacity. It's not necessarily a medical standard. So it's something that an attorney can determine in a lot of situations. So if that person has capacity, they can put together their own power of attorney. If they do not have capacity, you're quite limited. If you can't put together a power of attorney for yourself, you are leaving things up to the guardianship process. So an interested person will have to petition the court and ask for guardianship of you. Again, and I hate to beat on this idea, but planning ahead is just so incredibly important because it makes all of this much more simple and it keeps the power in your hands. I did get a question about cost. So cost is always dependent on how many different things you want to get set up. If you want to get a revocable trust, that's going to be different than the cost of an irrevocable trust. I'm not going to quote any prices because everybody's package will look probably a little bit different. And if you have an incredible amount of assets that are things like NFTs, or these very complicated types of assets, that will also cause the price to be higher. So I'm not going to quote any prices. You can shop around with an attorney. Oftentimes attorneys won't generally give you a blanket price because it is quite specific to each person's situation.
I don't know if this was the same one that you had addressed, but it's like, what is the average cost for an estate planner? But that's what you're getting at. It could be drastically
and all different attorneys have different rates that they charge for this. I can say for me personally, I'm a solo attorney, so I don't have an incredible amount of overhead. So my prices tend to be a little bit less than, the big attorneys, the big law firms in the area. But again, I won't quote anything in a public thing because I don't want to tell you a price and then it ends up being higher for things like that. I do see another question about.
Yes, I have one. Is it better to do a quick claim deed to add the intended beneficiary to a house versus putting the house in a trust?
That's a really good question. There are many drawbacks to adding someone to the deed to your house. One of the biggest drawbacks to adding someone to the deed to your house is that they are then a part owner of the house. You no longer unilaterally can take them off of it without their consent. You no longer have that asset protected from their debts. So especially when we live in a place like the DC area, I'm assuming a lot of people live in kind of the DMV where accidents happen all the time, people are getting sued all the time. If you were to add your son, for example, to your deed to your home, as a joint owner to your home, and he were to get sued because he caused a car accident, if he can't pay what the judgment is, that house is his asset to pay. So your house might have to get sold to pay his lawsuit. Essentially, any debts or creditors or lawsuits against that joint owner, your house is subject to paying those things off. That's number one, and possibly the biggest reason I don't recommend doing that. But again, you are no longer the sole decision maker when it comes to the property either. So even though your relationship is great now, it may not be great in 10 years. I don't think anybody ever foresees no longer talking to their child or their best friend or their sister, but you see situations like that unfold all the time. So I would always recommend doing something else besides adding somebody as a joint owner. Now, again, it's going to depend on your goals and your situation. Some people opt for life estate deeds. It's not exactly the same as a quitclaim deed. Some people opt to just do the trust because it gives you more flexibility throughout your life and you're not recording deeds every few years to update it or change it. So again, it kind of depends. I'm sorry, I know that's not a great answer, and I know that's always the least satisfying legal answer, that it depends, but it truly does depend. Although I would not ever recommend adding someone as a joint owner to your home, unless you're your spouse.
All right, the next one is who executes the trust and the trustees listed in the trust?
So
they want to know, is it the trustees listed in the trust who execute the trust?
Yep, so the trustees are going to be the ones that actually see the instructions in the trust. So if you are going to create a revocable trust and be both the trustor or creator and the trustee, you see the wishes through. And most of the time, your wishes as the existing trustor and trustee is just spend the money and use it how you want. But when you are no longer acting as the manager, we set a second set of instructions up, which essentially says, use the money for me, or if I'm gone, give it to these people in this way. And that is what the trustees will do. That's why it's incredibly important that you also have those successor trustees listed, because if your number one choice is not available, we go to your number two, then we have to go to your number three. Some people even have 4 people that are backups. I like as many backups as you can give me. Those people will see through the actual terms that you set in the trust.
Mm-hmm. Okay, we have another question. Ms. Hawkins, do you want to share your question?
Yes, I'm gonna let my husband speak on our question. Go ahead. His name is James.
Yes, my elderly father is still married, but he's been separated for many years from my mother. They're still in contact and everything. I recently moved him in with me, and he had a medical emergency and now has been diagnosed with early stages of Alzheimer's. So will him still being married affect me trying to set up his trust?
So that's a great question. First and foremost, married people can set up any document they want for themselves. Just because they're married doesn't mean the spouse has a say in it. That being said, you've also mentioned a diagnosis. He will have to have capacity to set up a trust. Additionally, in the state of Maryland, I'm not sure where you're a resident of, but in the state of Maryland, there's something called the elective share. So if you pass away and you're married and you leave your spouse nothing, they can challenge that, and they have a right to challenge it and a right to the piece of what you leave behind. So being married and being married when you pass, regardless of how long you've been separated, that person still has certain rights in the things you leave behind.
Okay, yeah, we're here in Ohio, so we're set with that.
I couldn't tell you what the rules are in Ohio, but generally speaking, many states do have the elective share.
Okay, thank you very much.
And I did have a couple other direct message questions, Jennifer.
Okay.
So I had one question about a son who is married, and whether or not that should affect whether somebody picks a trust or a will. So I do just really quickly want to touch on this because I think this is something that we don't necessarily consider. But if you set up a will and you leave everything to your spouse when you die and you pass away first, everything you own goes to that spouse. If that spouse has their own will and they say, I want everything to go to my separate children, when they pass away, everything goes to their children and nothing goes to yours. Because you, instead of leaving things to your child, have left everything to your spouse. And once your spouse inherits, they decide who it goes to. For that reason, a lot of folks with blended families opt for a trust. Because when you set up a trust, you can say, when I die, my spouse can have access to my things, but when they die, anything that's left goes to my kids. or you can completely separately say some goes here, some goes there. So you have a lot more flexibility with a trust and a lot less risk that everything that you own will go to a third party. And I do want to be cognizant of time because I know we go till 3, but we have a few more minutes here. There is a question here about yearly costs for trust. There is not an ongoing cost to maintain a trust, but this is an opportunity to talk about how much a trust is your own responsibility. So there is no network of trust. There is no government entity that keeps track of trust. When you create a trust, it is entirely private. In many situations, the person who creates it is the only one that knows that it exists or what it says. The key is that your loved ones or whoever you need knows where to find your trust when you're no longer with us or no longer competent. Only at that time can anybody else see what the trust says. And even then, the only people entitled to see the trust are the trustees and the beneficiaries. So when I say it's not public like probate is, I mean, it's entirely private. That being said, you don't have to pay yearly fees for it, but maintaining it and keeping a log of what's in it is entirely on you to do. So I just always want to mention that. I do have a question about my website. My website is johnson-legal.co. I'm actually going to go to the last slide here, although we have a couple additional questions. This is both how myself and Jennifer can be reached. So our emails, our phone numbers are on there. We did have the question from Ohio. I am licensed, just as a reminder, in DC, Maryland, and New York. So those are the states I could directly help you out in. I can't help if you're in another state, unfortunately.
And Ayanna, I have one question. The question is, I have a house in DC. My dad left it in a trust. If it stated, it stated that if I pass before my granddaughter, she will get it. Can I sell it if I choose now that the house belongs to me? And the person who said this, if I stated it wrong, you can unmute yourself and share it directly. And then let me just say one thing. If some of the things are so personal or so, different or complex, whatever, I'm sure Attorney Johnson would appreciate, you guys could give her a call or, send her email and then she can actually answer the question. So go on if you want to, if I made that clear, Attorney Johnson.
Well, I will just say, in situations like that, I would have to see what the document actually says because I can't. Well, what I find is sometimes that on first reading or even second reading, it seems like it's saying one thing, but I, as the attorney, need to review the entire document to see what the terms are. Some people might put together a trust that says you get the house, then you can do what you want with it. Some trusts say you can only use the house while you're alive. So all trusts are different, and it's not always in the one paragraph where it says that. It can be in different sections. So although I am an estate planning attorney and I draft these documents for a living, I also do consultations where people will send me their documents ahead of time and then we will sit down and review them together. So that's also something that I can do if you are unclear about what a trust says. Anybody who's watching, we can do that as well.
I have one last question. The trust is private. If you pass away, how will other people know about it, see it? What happens?
That's a really, really good question. So the key is that when you set up a trust, you are either informing your successor trustee that you have a trust and where it is, or you are keeping them abreast of what's happening in full. So oftentimes people have one cabinet in the home where they have a safe or a fireproof box where all their important documents are, and their oldest child or spouse or whoever it may be knows, oh, that's where dad's important documents are. So they'll just go there and find it. Other times you will tell the person, hey, when I'm gone, this is where my important documents are. It is totally private. So it's important that it's somewhere safe. A lot of people used to put them in safe deposit boxes. Banks don't seem to have those as much anymore, but I always recommend a fireproof safe if you've got it.
Okay, that sounds good. And yeah, okay. So I think everyone's question has been answered. Ms. Jacobs, again, I don't know if we answered your question fully, but I'm sure you can reach out to Attorney Johnson.
And I saw one last question about the probate process if the person doesn't have a will. If you don't have a will, then the court and the state that person lived in, I should say, is going to determine who gets what. So there is a process. You open probate and the statute will say it. So it'll say it right in the law that the legislator wrote. In Maryland, it depends on who you leave behind. Do you have a spouse that is still alive? Do you have minor kids? Do you have adult kids? Do you have parents? That's going to determine who gets what. So I would definitely say don't leave it up to that, because that's also subject to change. If your plan is, I like what the state says, who would get what today, that's great. But if you pass away in 2040 and they've totally changed it, you chose not to plan ahead, so we don't know who's going to get what. So that is how the probate process will work if people don't have a will. So.
Yeah. Well, thank you. Thank you, Attorney Johnson, and thank you everyone for chiming in and listening to this presentation. It will be on my YouTube page, so you get a follow-up email telling you where to go to it if you want to review it again. But I do appreciate you guys coming in today and logging in and getting this information. It's so valuable, and I'm sure every one of us has something that we need to now go and do. So don't wait. Make sure you plan ahead. We never know what's going to happen when we walk out of our house. It's not just about getting old. Things happen. So we do need to plan ahead. And so we definitely appreciate you, Ayana, for coming in and speaking to us today. So stay
Thank you, Jennifer, and thank you, everybody.
Yeah, stay plugged in. And look out for our next month's seminar. All right. Thanks, everyone. Have a great day.
Hey, everybody.